So, Chuck Rosenberg, you are my man on all things explanatory. Explain again to our audience what would be contained within the search warrant and what information we would get from the property receipt.
Sure, Katie. So 3 parts to a search warrant, generally speaking. The affidavit, which lays out the government's case for probable cause, which the judge reviews. The search warrant itself, which is typically a 1-page order, and the inventory that you alluded to, or the list of items that were seized. As the Attorney General said, that list of items that are seized, the inventory, has to be left at the home, and so Mr. Trump presumably has it. The 1-page warrant, the order, would be presented at the home at the time of the search, so Mr. Trump presumably has it. The thing we're all waiting for is the affidavit, the underlying probable cause statement, and that can run many, many pages. So the document you just held up in front of the camera, the motion to unseal, is a motion by the government, by the United States Attorney, to ask the court to make that document public, meaning there's no longer a legitimate law enforcement purpose for keeping it sealed. Whatever is in that document, we will soon see. Whatever's in the inventory, we will soon see. We can stop guessing, and we'll know exactly what it is they're looking for, what crime they believe was committed, why they thought they would find evidence of that crime in the place they were searching, and the things they took as a result of the search warrant. So the other part of this, Katie, I am not at all surprised, and I'm sure Neil is not surprised, and Andrew's not surprised, and any of us who grew up in the Department of Justice are not surprised that the Attorney General himself had personally approved this search warrant, this law enforcement action. It would have been utterly shocking had he not. It would have been a massive dereliction of duty. And, you know, I've been saying on television for a few days now, I think you can characterize it as my blathering, that it had to be the case. And so that is not at all surprising. Third thing, I'm very glad that the Attorney General spoke up on behalf of the men and women of the FBI. Like Andrew, I worked there. I had 2 stints there. I consider it a privilege of a lifetime, professionally and personally, to have been part of that great organization. And watching unfounded attacks on those men and women is utterly revolting. The notion that the FBI would have planted evidence at Mar-a-Lago is a sickening lie. And so I'm glad the Attorney General spoke up on behalf of these men and women. It was overdue, in my view.
He said, "I will not stand by silently when their integrity is unfairly attacked. The men and women of the FBI and the Justice Department are a dedicated, patriotic public." All right. So there are a couple things in this motion to unseal the search warrant and the property list. The warrant was signed and approved on August 5th, 2022. I'm not sure if we knew that before this. My second question to you, Chuck, was going to be, when are we going to know? When are we going to get this stuff unsealed? When will we get this information? And I know you're saying soon, but there's this last paragraph, and I'll read it. In this motion, it says, "This matter plainly concerns public officials or public concerns as it involves a law enforcement action taken at the property of the 45th President of the United States. The public's clear and powerful interest in understanding what occurred under these circumstances weighs heavily in favor of unsealing. That said, the former president should have an opportunity to respond to this motion and lodge objections, including with regards to any legitimate privacy interests or the potential for injury if these materials are made public. To that end, the government will furnish counsel for the former president with a copy of this motion." So what's your sense of timeline, Chuck?
Yeah, so that shifts it slightly, Katie. And by the way, I think that's a very sensible thing for the government to do. In the ordinary case, and I've done a whole bunch of ordinary cases, the government files a motion with the court to unseal the search warrant or the arrest warrant, the affidavits, whatever the documents may be, and the judge signs it. And so in the ordinary case, it would probably happen by close of business today. This is not the ordinary case. And so I think it's absolutely appropriate for the government to invite counsel for Mr. Trump to weigh in. Now, there is still a very, very strong predisposition in the law for documents to be made public because of the public interest in knowing what the contents are. So the judge may invite a brief from Mr. Trump's lawyers. He may hold a hearing. None of that would be inappropriate. To your primary question, it'll slow things down a bit. But this is the first step in getting the affidavit. And again, we ought to be careful in the interim of conjecture, of guessing, and of speculating of what's in it. We know certain things about search warrants, so we can tell you how they work. We can tell you how you obtain one. We can tell you the legal standard for it because it's contained within the Fourth Amendment of the Constitution. That's all stuff we know because that's search warrant law 101. But what's actually in the affidavit, what the procedural history was, which we alluded to earlier, whether they asked nicely several times, whether they issued grand jury subpoenas, whether they resorted to a search warrant because none of those other things worked, that will probably be in the affidavit too. And we will see it. We just have to be a little more patient now.
Just to help